Welcome back to the Texas Appellate Law Podcast. I'm Jody Sanders.
And I'm Todd Smith.
And our guest today, we're extremely honored. We have former Texas Supreme Court Chief Justice Wallace Jefferson. Chief Justice, thanks for joining us.
Well, thanks for having me. I'm excited about it.
Right before we started, Todd and I were kind of chatting with you. I think you're now our third chief to be on here, but we're excited. You've been on our list since we started to be one of our guests. So we're glad 6 years in, we finally can get you on. Well, I guess, I think the majority of our listeners know who you are, but I don't know, maybe they don't know about your background, anything like that. So maybe just kind of give us your background and your path to the bench.
Sure. I mean, just starting from my family, my father was in the military, United States Air Force. He and my mother had 6 kids. None of us were born in Texas because he was traveling all over the country from base to base. So we were born in Massachusetts and Nebraska and California. I was born in Washington State in Tacoma, along with one of my sisters, and another sister was born in Guam. So we moved to San Antonio for his last base assignment. That was Kelly Air Force Base before it was shut down with the Base Realignment Act. And that was back in 1967. Those are really where my memories started. I have a few from Guam, but grew up in San Antonio, went to public schools, graduated from John Jay High School, John Jay, the first Chief Justice of the United States, and then attended college at James Madison College at Michigan State University. James Madison College, founder of our Constitution, really the major framer of it. And then law school at the University of Texas School of Law, where I had Charles Allen Wright, who most everyone knows as, the author of the Federal Court Treatise and constitutional law professor, and well known among the United States Supreme Court justices. He argued there many times. He passed away in 2000, but he's been one of my mentors. Started at Grosslock and Hebden in San Antonio, and then in 1991 formed an appellate boutique. We think it's the first in Texas that did nothing but appellate law with Tom Crofts and Sharon Calloway. And that's where I was in practice as a partner in that firm when I went to the Supreme Court in 2001.
Before we jump into your Supreme Court years, pretty early in your career, you were able to argue before the United States Supreme Court. Talk a little bit about that experience, if you don't mind.
Sure. That was a fascinating case. It was a case that I argued in the Fifth Circuit, and it was not very long after the whole Rodney King incident. You remember the police chase, and my case was a police chase case. It didn't have the racial elements, but it was a 1983 action filed by a plaintiff who was a passenger in a car who alleged she was removed and injured during the police stop. So that's a case that I argued at the Fifth Circuit, lost 2-1, and then decided, this is a case that maybe the Supreme Court of the United States would take up. And so it was the first petition in the Supreme Court that I ever filed. And
wow.
And they granted it.
That's amazing.
The first the first thing I thought about is contacting my former professor, Charles Allen Wright, to see if he could help moot the case, and he did. And this was in the mid 1990s. I'll give you just a little vignette about it. One of the reasons I wanted, so Georgetown had by this time already set up a moot court, and you could argue to their moot court program at Georgetown. But I wanted to do it at the University of Texas School of Law, in part because this was around the time that Hopwood was being litigated. Remember, there were some people saying that, really African Americans should not be at this institution, or not in the numbers, and because they, lack qualifications. And I thought, well, let me show them that there's, a recent graduate. I was 8 years out of law school that is now arguing at the highest court, and open it up for students to watch. Just to show that there, as an example, that may not necessarily be the case, and that people can succeed. So Charles Allen Wright put together a moot court, argued it, and he asked, all of the questions that the Supreme Court would ask and more, and really got me ready for my first argument on election day in November of 1996.
Well, then you went on to argue the case as a relatively young lawyer, as you pointed out. So what was that experience like? I mean, I'm thinking about being 8 years into your career as a lawyer and taking your place at the lectern in that magnificent building in front of, 9 very interesting personalities, I'm sure. So besides the moot, how did you go about preparing for that at such a relatively young age?
Well, what I did was read every case, 1,000 times in the Section 1983 cases that the Supreme Court had addressed, and read the transcripts of all the oral arguments that I could get a hold of, where the current justices had asked questions, worked with my colleagues, and had other informal moot courts, and everything you do as an appellate lawyer to get ready for an argument. And then I flew to DC, and it was my first time ever in Washington, DC.
Wow.
So that was pretty incredible. I stayed at the Jefferson Hotel just for fun. Really, I didn't know anything about DC. But I had a couple interesting periods before the argument. The argument was on the Tuesday. On Sunday, I think it was, I appeared before Court TV. Do you remember that
Oh, yeah.
broadcast? And gave an interview with them. And then I also had an interview in CNN. And what I was thinking at the time was, I'll never do this again, probably. I mean, I'll want to, but this is pretty unique. And so when people ask whether I could be interviewed, I said yes. I walked into the CNN for the interview, and I had to convince them that I was the lawyer that was going to be arguing this case. I think they thought I was too young. I remember walking into the green room, and Trent Lott was there and William Bennett. They were there to talk about the presidential election. So I got to meet them.
Wow.
And then have my interview. And that's Monday night, I guess, is when it was broadcast. And that was the first time that I laid eyes on the plaintiff, because they interviewed her as well. The Monday morning, I went to the Supreme Court to hear oral arguments, just so I could get sort of a sense of the courtroom. And it was after that argument, I went up to a U.S. Marshal, and I said, look, I'm going to be arguing tomorrow, and you've seen a lot of these arguments. Do you have any advice for me? And, this was a not young, but a diminutive U.S. Marshal. She was probably 5'5". And, she kind of looked up to me and she said, well, I'm not a lawyer. I don't really know a lot of what's going on here. She said, but I can tell you this, the one thing. And she said, I've asked Scalia, how does he know whether, a lawyer who's, arguing here has any experience, knows what they're doing? And she told me that Scalia said, if the lawyer knows that at the podium, there is a handle on the right-hand side of the lectern, and if you twirl that handle, it'll raise the notes or lower your notes. He said, well, that lawyer's probably been here before. The SG always knows. And so if nothing else, I was prepared and working hard on my opening argument, but that just gave me a little, bit of information that I could use. And so when Chief Justice Rehnquist called the case, the first thing I did was twirl that, that crank. And I don't know if the notes went up or down, but it just kind of made me feel like I was doing. I kind of looked at Scalia, and maybe he nodded a little bit, and then I could get going. And it was thrilling argument.
If you couldn't tell it was going up or down, maybe you just got punked by the marshal.
Maybe so. But
no, that's a neat detail.
But everyone says, and it's true, the questions they come at you right away, and they're ferocious, and they don't let you go. And so it's a battle. You feel like you got to hold your own. And I took some advice from Professor Wright. He said, be very careful about conceding points. He told me this is going to be a close case, and you don't want to lose anyone who's in the middle, and they're going to test you. So be very careful. And there's one point where Justice Stevens asked me a hypothetical that seemed to me it was safe to concede, that it was so extreme. I said, well, maybe in that event, Justice Stevens. And as soon as I said that, not 2 seconds later, Justice Scalia, jumped up and said, I don't understand why you're conceding this point. It was just, just to show that Professor Wright, knew what he was talking about, and you had to be very careful. So that case, the other very, dramatic point was they kept asking questions, and at the U.S. Supreme Court, you got to reserve your own rebuttal time. There's not at least I don't recall a yellow light, but I knew when there was 10 minutes left, and then there was 8 minutes, and then 5 minutes. In my mind, I was going to reserve 5 minutes for rebuttal. And then there was 4 and 3, and the questions kept coming, and then 2, and then the time went out. And I'm the petitioner. And it meant that, I had waived my rebuttal time completely.
Wow.
And I'm thinking, this is devastating. I was thinking, what are you doing? And so as I'm sitting down, I'm thinking, that was horrible. But then I thought, well, it's also over. At this point, I could just sit back and I don't have to take notes, and I can just, relax and hear the rest of the argument. And then there was a point at the very end of my adverse counsel's argument where Breyer asked about the record. And he said, and it was about this is a case where the police officer that allegedly committed the violent attack on the passenger had a record himself. And it was really a series of misdemeanor traffic arrests, and with one incident that you might call violent, and that was a fraternity fight at the University of Oklahoma, long before he was a cadet with the police department. And so Breyer said, is that in the record? And my adverse counsel said, yes, it is. And Breyer said, well, I want to see it, so tell the clerk where it is in the record. And counsel said, yes, of course I will. And so that argument ended. And as we're approaching each other, he's extending his hand to congratulate me in the argument. I'm saying, well, congratulations, but it's not in the record. Bring it. And so I had a rebuttal, is my point in the end. The clerk had to go back to the court and let them know that this was not in the record. And that was a very important part of the argument. So,
But what do they tell advocates, or whether experienced or inexperienced? I mean, if you just continue to get grilled throughout the time of your opening, how do you gracefully end the opening part of your argument so that you do reserve time for rebuttal?
You just have to take control. And I've learned that since, I would have just said at 5 minutes, I say I have 5 minutes, may I address that on rebuttal? And the chief would have said, that's fine. And then bring the other lawyer to the podium. But I was, I should have known that. I didn't. And it's one of those things that you learn in practice, how to really kind of take control of the argument. My next argument at the Supreme Court was a couple of years later. And by then I felt like I had a little bit more command, of my argument and how I would address the court. In fact, even at one point I made the court laugh, and not intentionally, but I felt, comfortable enough to make a point that was somewhat humorous.
One other question I wanted to ask real quick about that whole experience was, you talk about it being sort of like a battle and you're just constantly getting grilled. This is also not a 20-minute argument situation like we commonly have here in our Texas state courts. I can't remember. What's the standard amount of time, or what time were you given for that opening argument?
30 minutes.
30 minutes
per side.
Okay. Well, that's not as bad as I feared it might be, but still 30 minutes of constant peppering.
It's longer these days, because the court lets it, the chief lets it go on longer. But I'll tell you what helps. What helped me, there are a couple points. One was where Rehnquist intervened when Justice Ginsburg was asking a question that, I thought was a little tangential, and Rehnquist agreed. And so that let me get back into my argument. So that was one. And the other was when O'Connor asked a question about the court's charge. And I was so ready for that question because I had, in looking at the transcripts of former oral arguments, it seemed like she always asked that question. She always had some question about the charge and what objection was made and what was the instruction and all of that. And so I had that, I didn't have the whole argument memorized, but I had that portion memorized. So when she asked the question, I just went through, seamlessly. And then that kind of gave me a little bit of confidence to go on. The rest of the
speaking of command of the courtroom, I want to transition into your Supreme Court years. You joined the court in 2001, I think. Is that right?
Yes.
When did you decide that you wanted to go that route and become a judge?
Well, it was more a question of getting an offer. So their first Raul Gonzalez left the court, and that must have been in I don't know, the late 80s or early, probably 1990s, somewhere around there.
90, I think he was on until 98, wasn't he? Because he was my judge, so I should know this.
Yeah, I said 90s. Yeah, the late 90s.
Yes.
Was when I got a call from someone I will not name, but who was not in Governor Bush's office, but asked me whether I would be interested in replacing Justice Gonzalez. And that would, and that went faster than I thought. The sort of activity surrounding replacing that justice. So I kind of hemmed and hawed, thinking I'm too young. And I know I'm not sure if I'm ready for that. And do I really want to leave San Antonio? And I'm doing this, et cetera, when the replacement was named. And that was Al Gonzalez. And I thought, okay, maybe I had a little bit of an opportunity, but I blew it. And well, that'll never come again. But then George W. Bush won the White House. And one of his first decisions was to take Al Gonzalez with him to be White House counsel. So there was another vacancy on the court. And this time when I got the call, I thought I better, I'm not going to ever get three calls for even the possibility of being on the Supreme Court of Texas. I love appellate work. It would be amazing to be writing the opinions rather than just being an advocate before the court. And so I sort of leapt on it. And when they asked to come interview, I drove up to Austin and interviewed with Governor Perry. It was the first time I'd met him. It was an interesting time in Texas because when George W. Bush left, he took a lot of political heavyweights with him. And so Governor Perry was kind of, deciding on his own, what his own path was going to be. But so I got an invitation to interview. And I think it was for two reasons. One, John Cornyn, who I knew from San Antonio. He was on the district bench before he was AG. I had that connection, and I think he had a conversation with Perry's office. And Bill Jones was Governor Perry's White House was Governor Perry's general counsel, and I'd known him for a long time as well. I think those two sort of helped put my name in the mix, and I wasn't the only name. There were others, but that helped get me the interview to begin with, and ultimately he asked me to serve.
Am I correct that you were the first African-American justice on the Texas Supreme Court?
Yes, that's correct. That's in 2001. And you think of all the, decades, and it was pretty historic. So much so that when I was announced, I think on that same day or that same weekend or a few days later, I went to the San Antonio Spurs game in San Antonio. And, that day my name had been in the San Antonio Express News, and I was on the cover of the paper, et cetera. And so a few people recognized me, and this one old lady, came up to me and she brought her grandson, and she said, I just wanted him to meet you. And I'm so honored that, you're going to be on the court. And it just reminded me that this is, it wasn't a trivial thing for people to see that, someone like them could be on the Supreme Court, one day. And it struck me as important, not as, what I would do in office, but just as a symbol of where we had come in our state and in our country.
Well, to that point, relatedly, you've spoken several times about your personal family heritage and how it was your great grandfather or three great.
Mm-hmm.
Your third great grandfather actually was a freed slave, if I remember the story correctly. And so, I've heard you talk about that before, and you're right. The whole historic significance of your appointment and then subsequent elections really shouldn't be lost on anyone, considering how you were able to trace that history. Tell us a little about how you found that out and how that's impacted you in your public service.
It's all. I would say it started with my father and with Roots. You remember that Alice Haley book, and then TV series in the 1970s where he traced his ancestry back to Africa. And I remember watching that with my father, and we went right around that time and got the old family Bible out, and where you could see my father's mother and maybe grandfather or grandparents, and that's about as far back as it went back in those times. But my father caught the bug, the genealogy bug. And so he kept, trying to sleuth, figure out this and that. When I was in law school, my first year, and I saw the Texas Genealogical Library and State Archives, I thought this would be a place to look, because although I wasn't born in Texas, nor my father, his mother was born in Palestine, Texas, in Anderson County. And so there was, generations before her that lived in Texas. And so we decided, let's see what we can find out. My grandmother was still living at the time, and she knew who her grandmother was, but not beyond that. So we just did a little research in those archives and library and found the name of Shedrick Willis in an obituary. Shedrick Willis was the person you mentioned, my great 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 grandfather. And the obituary said Shedrick Willis, well known Negro, dies at age 86 in 1903. And before the war, he was owned by Judge Nicholas W. Battle. And that was the first time we were reading this. And we're like, oh my goodness, this is the first that we knew of. My dad and I were standing there reading this together. So that's how we found out to begin with. And then, you do a little more digging, and there's not a whole lot you can find directly about Shedrick Willis, not right away at least, but you certainly could about Judge Battle. We found out, he was a very prominent, he was a colleague of Baylor, the Baylor of Baylor University in Waco at the time. He was a former district attorney, and then he was district judge, and then he left to fight in the Civil War. And, so there's all kinds of information about him. And then digging a little bit more about Willis, we found out that he was a blacksmith. And we knew that because there's in another obituary in the Dallas Morning News, it said, something like this well-known carpenter, had died, but he in 18, whatever, I don't know if it said the year, but before the war, he shod Sam Houston's horse, and he was kind of famous for that. And that struck me as very interesting. Anyway, after the war, he had a shop in Waco, and there's an advertisement in the Waco directory that I've got a copy of it on my wall here in the office that says he's blacksmith, wheelwright, and horseshoer. And so anyway, so he found a way to for the labor to support his family, financially, rather than go to an owner. And then the most incredible thing was in the first obituary that I talked about that my father and I read, it said that he served 2 terms on the Waco City Council after the Civil War. So this is somebody who was, private property one day, and a couple of years later, a public servant, a leader in the community in Waco, Texas. And it's just amazing to me that happened, and that I'm, as his descendant, who was owned by a judge, became Chief Justice of Texas.
Well, that's an incredible story.
And then the kicker. So then I joined the law firm here, Alexander Dubose Jefferson, and that was after I left the court back in 2013. And that same year, within months, the firm brought Marcy Hogan Greer to the firm as a partner. She was, an outstanding appellate lawyer and commercial litigator at Fulbright, and then she joined our firm. And then I had a conversation with her one day where she said that she was the great, great, great granddaughter of Sam Houston.
Wow.
So we had that connection that we knew nothing about until, we joined forces as partners at the firm.
History, and it's an amazing thing when you study it and you see paths cross like that. That truly is. For y'all to be partners now after that, sharing that history is just incredible.
And I'll say, and this is kind of what I will say as president of the American Law Institute, and I'll do that for a long time. Today we're in a situation where the country is at odds and everyone is polarized, and you're supposed to be in one camp or the other. And if you're in this camp, you're supposed to hate that camp, and there's no way you can get along. And this is just, to me, this story is a symbol of our nation overcoming those sorts of divisions and finding what needs to work together and to compromise, no matter what happened before. And that's what, to me, our Constitution and our history bring that is unique in the world. And we shouldn't despair. Even today, we shouldn't despair that we can find ways to work together in a very productive way, no matter what our differences. And that's why it's one reason I was so happy to be elected to be president of the American Law Institute, because it's an organization where there are fierce disagreements about the law. And these are very important debates where, there are advocates on all sides, but they come together. They're excellent lawyers, professors, and judges, and hash it out in a civil way and make some compromises. Hopefully, if the job is done right, they are producing products of a more modern and clear law that is to the benefit of lawyers, but more importantly to the lawyers' clients, that are dealing with these very serious disputes.
Well, we wanted to talk with you in detail about your ALI presidency, and so that's seems like a good segue into that part of the conversation. How did you first get involved in ALI, and maybe tell us, the quick summary of those of us who are lawyers certainly know what it is, but for maybe those who don't or don't appreciate it, tell us what ALI does.
Well, first I didn't know what ALI was, but I knew what the restatement of torts was because that was kind of our Bible, in torts class in law school. I knew who Dean Keaton was, who was a reporter for the Torts Project. And through that, I think I learned about ALI. And I already mentioned Charles Allen Wright was my professor. He was my professor for constitutional law for federal courts and for a Supreme Court seminar where each one of us played the role of a sitting U.S. Supreme Court justice, and we decided the cases that were court that term. And a lot of the sources were restatement provisions. And that's when I learned about Charles Allen Wright's involvement, and he was president of the American Law Institute, my former professor. So I always held it in high regard. And then Professor Wright had the idea, as he was president, to make sure that the justices of the Supreme Court of Texas were members of the American Law Institute. Because what the Institute does is work to modernize and improve and clarify the law for the better administration of justice. It is not itself law. And so the only way it is adopted is through courts. And one of the best ways for its adoption to occur is through Supreme Courts, either the Supreme Court of the United States or the Supreme Courts of the states and territories. And so one of his projects was to make sure that Supreme Court justices became members of the American Law Institute so they would study the work, and if they believed that it was an accurate portrayal of the law, adopt it in their states, and that way it would resonate, nationally. So that was Professor Wright's plan. And although he died in 2000, it became very clear to me that it was also Tom Phillips and Nathan Hex and others on the court's adoption of that. So they encouraged me to accept a nomination if it happened, and I was nominated to be a member and then elected, and that was in 2001, shortly after I came to the court, and started going to the meetings and was just fascinated with what happens at those meetings. You walk into a big room, where there's 1,000 people, and there are microphones, and there are reporters that are talking about their project. It might be torts or property or contracts or conflict of laws or, you just think the Uniform Commercial Code is a joint project of ALI and the Uniform Law Commission. It could be, so those are the topics. And then you see walking up to the podium, the people you read about every day as a law student and as a lawyer, the famous judges and the great lawyers and the professors of, high esteem. And they're just debating these very, important principles. And then they may be debating something that you're working on, and you start understanding that there's a great source of information that is much bigger than maybe you were looking at as a law student or as a lawyer. And the level of sophisticated argument is so much higher. And I was intrigued by that and loved it and loved being part of that process. And as a member, you can contribute and you comment on drafts, and they're considered seriously if you're serious. If the questions that you're asking or the suggestions that you're making are serious, they're going to be really debated. So that's what made me excited, and so I was happy to be a member. From 2001, I just celebrated my 25th anniversary. 25 years with ALI in 2026, and just a couple of weeks ago was officially installed as president of the Institute.
Congratulations.
Yeah, that's a big deal.
Thank you.
So where do you see the ALI kind of going moving forward? Is their mission going to remain the same? I mean, especially when we have things like AI coming into the profession, do you see them kind of intersecting with that?
So everything is changing in the law, and AI is a big reason for that. So yes, this is something that the Institute is going to be grappling with for a long time, but hopefully in a productive way. So one thing that the ALI does, we're not a tech company, we're an ideas company, and our model is to share the information. After this process, we go through this process. We want people to read it and to apply it. And what AI does is accelerate, that process. And so we're in a way we're actually we're not really a publisher, but our products are published. And now in publication, everything is available because you have all these, companies out there and bots and, AI, Chat GPT and Claude and everyone else that's all they do is they gather all this information, but they don't always do it accurately is the problem. And we know that with hallucinations and, court opinions, it's true also for ALI. So one thing that I think we can start concentrating on is being the gold standard, to make sure that if you're citing our work, maybe there's some way to make sure that it is the work, that it is accurate, and make sure it's available to the public in an accurate way. So those are some of the things we're working on. Also, we've got a project looking at, like in tort, where does AI come into that? So you've got autonomous vehicles that are involved in accidents. You can't. What's the standard for reasonable autonomous driver?
Who's negligent?
Yeah, and what does it mean to be negligent? If you're
Right.
technology. So there are all kinds of interesting things that AI is looking at with respect to artificial intelligence right now.
How does ALI intend to balance the incredibly rapid pace at which the technology is developing? I mean, everything I hear and read is we're going to get to, agentic or super intelligence within a much shorter period of time than anyone would have suspected even 5 years ago. ALI, as I understand it, as how you've described it, is there's a lot of study involved and recommendation and discussion and debate. That is a great process. I just wonder about how there's going to be time to do that when the technology is just blowing past everybody.
So that's exactly right. But we also have in ALI the lawyers and the professors and the judges that are working on these issues every day. General counsel and the judges who are presiding over these cases, the lawyers who are presenting them, patent lawyer, I don't actually know the answer, but I do know that we can tap into their expertise. They're members because they are excellent in what they do, and they can help advise us on how to work through these issues. And what is the answer? So we, tomorrow there might we open the paper, and you won't open papers anymore, but you'll get, you'll get something on your phone that says there's a whole new huge development that some AI company is developed that's going to change everything. So I don't know. We're going to have to act faster than we have in the past and adapt more quickly, but never give up the quality. The intense analytical work that human beings can do. I think still in many ways better than machines. And I don't know how long that will be true. But the human dimension, there always needs to be, I think, just for morality, for humanity, there's got to be a human being involved in everywhere that AI exists. And I think that's especially true in the law. So it's a good question, and it's not answered today. And I think it's going to be
fair.
We're just going to keep working on it.
How long is your presidency?
It's a 3-year term with a 3-term max. So maximum 9 years. We just celebrated in 1923 100 years of ALI. It was established in 1923. Howard Taft was, William Howard Taft was involved, and the leaders of the law in that era who understood that the law was being developed in different ways in different states and territories and state and federal court, and it was becoming a mess. And so we had to have some way to at least think about uniformity. And those founders understood it wouldn't mean that ALI could dictate to any court, what the black letter would be in the law, but they could offer best practices, best code to courts, and we're now offering it to legislatures in our principles projects to make, again, for the better administration of justice. And I think that general idea still holds true today. And I hope we can use that to tackle all of these new iterations and new technologies that are coming to bear.
Well, it's an exciting time for you to take the leadership of ALI, and I'm sure somewhat stressful with all of this stuff coming on the horizon, or even, like you say, every day you just open an app on your phone and you've got some new breaking news about some technological development. So, but I think, those terms, that 3 years with up to 2 subsequent terms, and it does provide the opportunity for some continuity of leadership, it seems. So I'd say again, congratulations, and maybe I'm sorry.
Well, I'll tell the audience listening to this, send me ideas. This is and send ALI ideas. Our director of ALI is Diane Wood. She's a former chief judge of the Seventh Circuit Court of Appeals graduate, coincidentally, of the University of Texas School of Law. Her professor was also Charles Allen Wright. So we got some Texas connections in ALI, but our reach expands throughout, from coast to coast and international. And we're looking for, the best and the brightest comments on projects and new projects that maybe we should be taking out. I'm all ears. And I think that is the strength of our organization. And that is the participation on a voluntary basis, of the best and the brightest in our profession.
Well, we're kind of talking about futurism and kind of where the law is headed. One of the big achievements, I think, when you were Chief Justice is starting cameras in the courtroom and streaming oral arguments. And I guess now we're almost 20 years into that. How did you see that change? Did you see a change in the way that lawyers, acted and all that? Because I think that's always been a fear at the U.S. Supreme Court. I'm just curious about your experience.
The biggest change I saw was in the way judges acted. And I'll say it in this way. When you know that there are going to be cameras in the courtroom, you have to be, you have an incentive to be more prepared for oral arguments. It made me, I would say, hypersensitive to being as prepared as I could be so that my questions were intelligent and, to show that I understood what was going on in the case. And I think that was true of my colleagues as well. So that's number one. I think it was very good for the court and as an institution to be even better or more fully engaged in the argument process, which is important to lawyers, but again, ultimately very important to the clients, to know that when they had their day in court, it was a completely a thorough examination and fair of both sides. So that's one. The second thing I would say is, we were warned that lawyers would play to the cameras, right? And this is a fear that, people talk about at the U.S. Supreme Court too, that this is, that'll be the ultimate impact. But I think both of you know, and the audience out there who are appellate lawyers know, and that's really hard to do because you can start, and I can remember one example of what I thought was a lawyer trying to play to the camera. They start that way, but then the questions come. And you have to answer the questions,
That's right.
And it's not a jury argument, and doesn't matter how much you flail your arms, the question, it's more of an intellectual exercise. It's somewhat academic. It's the premium is placed on preparation. The judges are prepared, but if the lawyers know the record and the law, they're going to be much more effective at the podium than they would be with emotion. So very quickly, you're centered on the right thing in an oral argument. And that happens whether the cameras are there or not. But what the cameras do is open the process to the public. Public can see law at work, and it opens the process to law students, who want to see how an appellate argument plays out and how they could do, how they could be an appellate lawyer themselves. And it opens it up to journalists who, now if you're a journalist in El Paso, you don't have to drive down or fly down to Austin, Texas to see what's happening. And it opens it up to the legislature. They see that some of these, maybe there's a statutory fix and they can watch, the debate about a statute that they helped, put in place. And so there's so many different ways that this benefits, I think, the public and the development of the law. If you have a case that has some relationship to one that's going to be argued next week, you're going to watch. won't you? Because you're curious how this is going to impact your case. It's either in the trial court or the Court of Appeals, maybe ultimately to the Supreme Court. So it helps develop a lot more intense interest in what the court does. And on top of that, I think it wouldn't have been as effective to open it up, to oral arguments and put cameras in the courtroom if we hadn't also, a couple of years after cameras, made electronic filing available to everyone. And so now you can watch the argument, but you can also read all the briefs. You can pull them up in an instant.
Yep.
And that, I think, was that again, it's the kind of transparent. We can't be transparent about everything, but it's the kind of transparency that makes, I think, you have a greater appreciation of what the lawyers are having to go through and what the judges are facing with these complex arguments. It enhances faith in the court system, and I think that's important because that's what we rely on. The judges, it's often said, and it's true, you don't have power of the sword, you don't have the power of the purse. It's the opinions, it's the judgment that you release that are important.
Power of the pen. Yeah. Well, I've been really pleased at how the Supreme Court's adoption of video at oral argument has sort of trickled down to the intermediate courts of appeals too. And it's good and bad. I mean, as an advocate, you get to go back and critique yourself, I guess, and it's preserved for posterity, rightly or wrongly, or good or bad.
True.
But that's been I think a really nice benefit. And, I know the Supreme Court, U.S. Supreme Court has resisted it, but I think, the Texas Supreme Court, okay, it's a state Supreme Court, but, the issues that come before that court are hugely important and lots of dollars at stake. And sometimes they involve, big time political issues. But for, the national media, maybe the coverage is not the same in your former court. But it's difficult for me to really understand, other than just not wanting to do it or, just history, why the U.S. Supremes would be so resistant to it. If there is a way to do it, you can't prevent someone from grandstanding or showboating, but the people who appear in that court on a regular basis, it seems to me that wouldn't want to be the reputation that you would want to get as an advocate there, is someone who's playing to the camera.
Yes, but on the other hand, and this was true at the court, at the same time that, I'm opening up, the court for cameras, with cameras, I'm also enhancing security at the court itself, because the Supreme Court of Texas got threats, judges do. Well, the U.S. Supreme Court, I mean, that's an exponentially, I think, more dangerous aspect of their jobs. You get these people that are just crazy. We've heard about people outside of Kavanaugh's office. Home. We can't imagine what kinds of threats they get that are serious, where you really need the U.S. Marshals to become involved. And so the more public you are, the more you expose yourself to these sorts of potential threats. And so there's a lot more, I think, to go. So you have to think about it in terms of balance. They have done. They have opened up. You remember when we first started practicing, or at least when I first started practicing, you wouldn't have access to even audio tapes. Those were only reserved for academic studies. For professors could come and listen to some of those tapes, but they were prohibited. The public was prohibited from accessing those generally. So there's been a whole lot of opening up of, about at least the access to the audio of Supreme Court arguments. I think that's been a huge step. And I would also say I would not have wanted anyone else to order the court to do this. I think it's a third branch decision on whether it is something that ought to be done. And so read about, efforts to force the U.S. Supreme Court to do this or that. I don't think that's right at all. I think that's got to come from the court itself, understanding, all the pros and cons. It's not just about people, being flashy at arguments, but it's about a lot more. The dignity of the court. They have traditions that are important that we want to see maintained, and about safety and all those issues. And that's got to be a conversation that the justices themselves have. That's my opinion anyway.
Well, we do in the meantime have there are podcasts out there that reproduce the audio. OEA is one of them. It's a helpful listen if you want to hear what actually happens inside the courtroom at the Supreme Court. And to the point about Supreme Court arguments, kind of the worry about it becoming performance art, I'm not going to say it's completely illegitimate. We've seen an example in the media recently that even resulted in a TED Talk coming out of the big redistricting case from Louisiana. I think Neil Katyal was taking a lot of credit on Twitter and ultimately in his TED Talk for how much his advocacy helped sway the result in that case. I guess anybody could do that, with or without cameras, but I don't mean to be dismissive of any concerns about that. It just seems like, I understand and agree with your point about, history and tradition when it comes to maintaining the dignity of the institution. And there's still, to some degree, people can still go and say things after the fact, like that particular advocate did that, there's been a lot of commentary made about that.
Yeah, that's true. I'm still a fan. I think it's still good. And I think it's good for all the reasons that I mentioned. But in the end, I think the court has to decide. But I'll say this: when the public, it's like when you ask a juror, what was your experience? You sat through the trial and you rendered a verdict, and now you ask them a week or two later, and they say this was a powerful experience, and it really impresses them that the legal system works and that it is serious and it's important, for a person to have their day in court. I think the same is true when you watch these oral arguments. There are a lot of caricatures about justices on the Supreme Court of the United States and justices on the Supreme Court of Texas. You have caricatures and people are quick to read a headline and come to an opinion about the all-Republican Supreme Court or whatever it is. But when you start and when you have the access to watch them as much as you can do their work, you see that often they're grappling with very important questions about what a statute means or what where the common law is headed, or the tension between a farmer and an urban business on water rights, or whatever it is. These are very hard questions, and you see the court trying to work through them. And I just think it helps as kind of a civic education. It helps people understand their democracy better.
This question relates to the topics we've been discussing. I mean, it seems like we've covered two major accomplishments that happened while you were Chief Justice. We talked about cameras in the Supreme Court courtroom, and I think you're right. I think that certainly helped the court's appearance of transparency and has been a really good thing overall. And you also mentioned e-filing. I mean, and those are both, significant developments that happened during your time as chief. And so you've certainly left your mark in that way. Is there anything else during your time as the Chief Justice of Texas that you're particularly proud of that the court accomplished?
Well, yes. I mean, maybe even bigger than those two is access to justice. We worked very hard on establishing a relationship with the legislature in which the legislature promoted access to justice. We had never had direct appropriations from the legislature to legal aid. And time before 2000, I think it was 2011 or so, and argued to the legislature, this was during a time, that there was an economic crisis in 2008, and the IOLTA programs were just plummeting because the interest rates were going down and down and down, and that's what funded legal aid programs through our IOLTA programs. And so I was talking to the legislature that all the money that was there is drying up. And so there are people who are now no longer able to protect their basic civil rights, civil legal needs. And so that year, the legislature appropriated, millions of dollars, and they haven't stopped since then. And that's let more people get their rights where you can't afford a lawyer. Where else do you turn but to, pro bono or legal aid organizations to do so? And if you don't have funding, most of our legal needs can't be met. And it's not just for poor people, for people who are middle class. You can't afford a lawyer to argue about the fence that, fell down in your backyard, or you're a small business and you're sued for breach of contract. So that's one thing that, you put on the table for all branches, legislative, executive, and judicial, that we have to do better about making the law accessible to all of us, whether you're rich or poor or in between. And so I think that was a major accomplishment. And then one thing people don't really know is, the, the court has its docket and decides cases, but the Chief Justice also goes to the legislature to talk about the general administration of justice. Is it working? And I'll just leave you with one other example of that, and that was in the area of juvenile justice. There was in the 2000s, it started in the 90s, more and more police officers on campus that were issuing tickets to kids, misdemeanor, Class C misdemeanor tickets for violating school codes. And I'm talking about things like yelling at the teacher or a fight in the hallway or wearing the wrong clothes. Those sorts of things were resulting in tickets. And when you had, and I went and visited a juvenile court and to see what does that mean? And that means, single mothers have to come to court and try to argue their case without a lawyer to get a ticket dismissed where, it's a $200 ticket, whatever it is that they can't afford. And many of these kids wound up being, suspended or expelled. And so we had a public hearing at the Supreme Court to say, does this really make sense? And then I could take the results of that hearing and go to the Judicial Council, which is the public policy-making arm of the judiciary, and think about, going to legislators and saying this needs to be reformed. Anyway, the bottom line is it was. And from one year to the next, there were hundreds of thousands of fewer of these tickets being given. And that meant kids were staying in school longer. So there are things like that the courts can do that are outside of the docket, but important to the overall legal landscape that Chief Justice especially can be doing out there. So things like that, I think, are important. And Chief Justice Heck, continued all of those programs and more. He also looked at mental anguish. He looked at what does a court do during a COVID-19 situation when all the courts are closed, but trials need to keep going. And again, those are not specifically docket type things, but they're ways to keep our legal system healthy so that they, can react to the legitimate needs of Texas citizens.
One thing that I think you've spoken out since your time on the bench and other former chiefs have as well is partisan judicial elections. I mean, do we think that's going to change realistically in Texas anytime soon?
I think likely not, but it doesn't mean that we shouldn't keep talking about it. We will have an election coming up, and this has happened before where, potentially just because of what happens at the top of the ticket, many talented judges lower down are swept out of office, not because they were bad at their work or that they were slow or inefficient, but because for that year, they had the wrong political affiliation by their name. And that still doesn't make sense to me. We shouldn't have that kind of system. I have no problem with a smart, hardworking Democratic judge, even though I hope a smart, hardworking Republican judge. We want the judges that are going to apply the law as objectively as they possibly can, Republican or Democrat. And they shouldn't be swept out because, some of the top of the ticket, sort of, taking the wind out of their sails. So that's where I think one of the problems is it focuses less on merit than it does on party affiliation. And if it doesn't focus on party affiliation, then it focuses on the sound of your name. Jefferson was a good name. Yackel was not in Travis County. It's hard to win with that name. He's a great judge, great federal district judge, now retired. But that's just an example. So if it's not political affiliation or the sound of your name, then it comes down to how much money you can raise and get on TV. And if you think about it, none of those tells you sound of your name, political affiliation, money. None of those say whether you're going to be a good judge or not. And that's the problem. We need to focus more on the merit of and experience of a judge than those, other factors.
Well, Chief Justice Jefferson, this has been a great conversation. We've certainly enjoyed spending time with you this afternoon, and thank you for all your time and willingness to come on and talk with us. Congratulations again on your ALI. election as president. That's an exciting thing to have happen, and look forward to monitoring, watching your leadership in that organization for the next several years. But before we let you go, our tradition is to ask our guests for a tip or a war story. It could be related to appellate practice, and you're certainly well suited to provide that. We haven't really talked that much about appellate practice per se, because we've had so many other good topics to cover. I think it's going to be great for our listener. But it'll be great for our listeners. Do you have a tip or a war story to share as we part?
Well, I'll tell you this war story, and it's related to the petition that was granted for my first case before the U.S. Supreme Court. So this was a case where I represented Bryan County, Oklahoma, and it was the police pursuit, excessive force case, and we were defending that case, and our side lost at the district court, a jury verdict. And so we appealed, and I lost 2-1 at the Fifth Circuit. And so then I tell the client, we should take this up to the U.S. Supreme Court. Now, this is a public entity. I'm talking to the commissioner's court in Oklahoma, and they go to me and they say, look, we keep losing, and we're spending public funds on this lawsuit. And they say, we're not going to spend more public money to keep losing. And they say, no, thank you. And so then I go back to them, maybe a few days later, the next week, and I said, look, I believe in this case, and I think we have a real shot at the Supreme Court. So let's do this. Don't pay me. I will file the petition for cert for free, and we'll resume, the billing relationship if they grant the petition. And so they said, under those circumstances, yes, you can file that petition. And I say that as a way to say, find your own way, and you don't know where it's going to go. But as a lawyer, if you believe in a case, find a way to get it presented and take risks, take some risk. And sometimes they pay off. If I had just let it stop at, we're not going to take it to the Supreme Court, I probably never would have gotten on Governor Perry's radar, as an appellate advocate. But I wasn't thinking that then. But, I'm just saying, just take some risks and take some chances, and they'll, believe in yourself. It's not just, and it's not empty belief. You do the work to have the experience, but believe in yourself and take risks, and they ultimately they can pay off or make you feel better about yourself.
Well, we certainly appreciate that piece of advice, and certainly have, you've got the benefit of all your experience in presenting that to our listeners and watchers. And thank you again, Judge, for being with us.
Thanks for what you're doing. I said it's important. It was important for the court to have cameras in the courtroom. It's important to the public also to have podcasts like this that delve into, what we do as lawyers and what happens in appellate courts. And I think the more exposure that the legal profession has to the public, the better, because they understand there's a place to go in which, if you have the law behind your side and a good advocate, you can prevail against all odds. And you're telling those stories through these podcasts. So thank you for what you're doing.